Good morning, good afternoon, good evening, depending on your time zone. Welcome to the opening ceremony and keynote address for the 11th Annual Cambridge International Law Conference.
My name is Jing Qing.
And I am Tejas Rao. And together, we are co-conveners of this year's conference. Alongside our staff, we are extremely excited to host you over the weekend. Please do not hesitate to contact us via email should any queries emerge as the conference pans out.
Without further ado, we would like to welcome the editors-in-chief of the Cambridge International Law Journal, Darren Peterson and Oliver Hellis.
Well, welcome everyone to the 11th Cambridge International Law Conference organized by the editorial board of the Cambridge International Law Journal. My name is Darren Peterson, and along with Oliver Hales, I am the current editor-in-chief of the journal. We regret that for the third year in a row, the conference is being held in a virtual format, but that is our only regret. The conference conveners, Jane Chin and Tejas Rao, have developed a stellar lineup of 8 panels. On behalf of the journal, we would like to thank Jane, Tejas, and their team of conference assistants for their hard work. And we are especially grateful to our 3 eminent keynote speakers, Dr. Rao, Ms. Gruff, and Professor Peterson, who will be properly introduced in due course, and to all of our panel chairs for their assistance with the conference.
As you know, the conference theme is strengthening global governance through international law, challenges and opportunities. At the current moment, however, it might seem as though the world is awash with challenges for international lawyers and very few opportunities for strengthening global governance. What hope is there for sustainable management of the global commons, for instance, when Russia is riding roughshod over the fundamental principles of international law? We reaffirm the recent statement of the fellows of the Lauterpacht Center, who strongly and unequivocally condemned the unprovoked and ongoing aggression perpetrated by Russia against Ukraine. In light of these events, our ambitious theme might give the appearance of lawyers trying to run before they can walk. Yet the war in Ukraine has drawn attention to novel infrastructures of finance, trade, telecommunications that are increasingly weaponized. As Professor Fleur Johns and Anastasia Kotova recently observed, authority, law, and order are mediated by money, memes, and megabytes on the international plane today. These are just some examples of how the present war calls for lawyers not only to defend the fundamental principles, but also to identify opportunities for strengthening the global governance of diverse fields in a manner that advances the age-old goals of international cooperation and peaceful dispute settlement. The ongoing perils of the climate crisis and the COVID-19 pandemic should also remind us that solutions must be coordinated on a global scale.
Over the coming days, you'll hear from panelists on the roles of international tribunals and other actors in strengthening the global governance of fields such as human rights, cyberspace, economic relations, and the natural environment. We congratulate all panelists on preparing their 8,000-word working papers for circulation in advance of this weekend. This requirement was introduced this year to ensure that all panelists are well prepared to submit their final papers to the Cambridge International Law Journal for possible inclusion in issue 2 of volume 11, which will be published this December. Next week, we will announce the formal call for papers for up to 12,000 words on any topic in the broad fields of public or private international law, as well as EU law. We also invite you to submit posts of up to 1,500 words to the journal's blog, which provides a venue for testing new ideas and responding rapidly to current events. Blog posts can be submitted to us at any time. We are also pleased to announce the articles that have passed the rigorous process of double-blind peer review for inclusion in issue 1 of volume 11, which will be published this June. This issue of the journal opens with a fitting tribute to the late Judge James Crawford and his masterful role in bringing the Articles of State Responsibility to their second reading. This piece is authored by 2 of Judge Crawford's former students, Dr. Federica Padu and Professor Christian Tams. The second article is an expanded version of Professor Simi Payne's lecture on responsibility to the international community for marine biodiversity beyond national jurisdiction, delivered last year as the annual lecture co-hosted by the journal and the Lauterpacht Center for International Law. Other contributions include Zi Hong Lam on the jurisdiction of the International Criminal Court in the contested territories of Taiwan and Palestine, Yilan Wang on the gap-filling role of general principles of international law, Sarah Lupi on the possible standalone crime of providing weapons for the commission of other crimes and human rights abuses, Dr. Tibase Morgandi on parent company liability under private international law, and Alexander Ferguson's review essay of recent titles on intellectual property and investment protection.
Thanks to these authors, and as always, our editorial team, the Lauter Park Centre, our publisher Edward Elgar, and our academic review board. The team at Edward Elgar Publishing is offering you all a 35% discount on their law titles. So to access this discount, please refer to the first page of your conference program. We'd like to announce for the first time the expansion of our academic review board to include 4 new members. Dr. Orpheus Hasapes-Tarsenis of Caius College, Dr. Richard Clements of Tilburg University, Dr. Natalie Jones of the Centre for the Study of Existential Risk, Dr. Emilia Lenate of the Cambridge Faculty of Law, and Dr. Rita Cabra of 3 Crowns. All these scholars were formerly members of the journal's editorial board, and we thank them immensely for returning in this new capacity. We rely on the service of senior academics to ensure that we build our reputation as one of the best student-edited journals in the field. One of those academics is with us here, Professor Catherine Barnard, who, along with Dr. Kate Miles and Professor Jorge Vinuales, serves on our faculty advisory board. Shortly, Professor Barnard will introduce our first keynote speaker. But we'd like to end our opening remarks by thanking all of you for attending this conference, with nearly 1,000 online registrations being the silver lining to our move to a virtual-only format. We hope that the rich and varied papers presented this weekend will renew your confidence in the capacity of international law to strengthen global governance at this moment of overlapping crises. And of course, we hope to see you all very soon in Cambridge. Thank you very much, and over to you, Professor Barnard.
Thank you very much indeed for that. And I would like to begin by thanking all of you for such an extraordinary amount of work to pull together such an impressive programme. Impressive and, as we know, timely. Those of us in the West are totally preoccupied by the war in Ukraine. I know from seeing the welcomes on the chat function that the audience here comes from right across the globe, and you will also have major preoccupations in your own area. But what we realize is that international law is both never more important, but also never more challenged. And that's why it's so timely to have Dr. Rao to speak to us this morning and to give this inaugural address. Now, as you know, he is an extremely distinguished international lawyer, a former member of the International Law Commission, and special rapporteur on the subject of prevention of liability. He's also been an ad hoc judge at the International Court of Justice. In India, he was head of the Legal and Treaties Division, Ministry of External Affairs, and was the chief legal advisor for India on international legal matters from 1985 to 2002. So it's hard to think of someone who is better qualified to address you this morning. He will talk for 15 to 20 minutes or so, and then there will be plenty of time for questions. Please submit your questions via the Q&A function so I can see them coming in, and I will try and get through as many of your questions as possible. Dr. Rao, a huge thanks for your time. The floor is yours.
Thank you very much. Am I audible now?
Do you want to just keep talking a little bit, because you're
Yes.
rather faint?
Thank you very much for the invitation to join this 11th annual conference of Cambridge, of International Conference of Cambridge. I'm really honored to be amongst so many committed practitioners and students and teachers of international law all around the world who joined us today. We are celebrating not only the 11th annual Cambridge International Conference, but we are actually joining together today at a time of crisis that is again befalling the world order, to restate and to recommit ourselves to the importance of international law and to work for it. I have worked for my life in this, in different capacities. I still learn a lot when I speak to the younger people. I learn even more like any others. And I think their perspectives are very valuable, and we have together today a host of them. That makes my presence that much more humble, and as well as eagerly waiting to hear and learn from this interactive process that this particular conference offers us. But coming to the theme of the conference, the challenges, global challenges and the role of international law, I want to start by saying that challenges to world order are not new. They have been there ever since the world order has started beginning to fashion together since 1648. And wars and wars and wars have always been the bane of the international society, coming together in spite of technology, in spite of common purpose, in spite of the sense of international community we have today. And yet we have these divisions, we have these fears, we have these mistrust born out of ideological and long historical backgrounds that unfortunately keep keep us in a situation of review and reminiscing what can be done, what should be done type of thing. And that's what we're doing today. Well, if the UN was created in 1945 after 2 world wars, you can see the amount of need as well as the aspirations of that particular time. And the collective security system that was enshrined in UN Charter under the aegis of the Security Council under Chapter 7 of the UN Charter was supposed to be an improvement over the collective security system that was conceived and did not work during the League of Nations time. And the veto right given to 5 permanent members was essentially an improvement over the League system of unanimity rule in the Security Council decision making and the operation of collective security system, which did not function at all. So they thought at least they should be able to get away with the unanimity rule, but they did not want to get away and could not get away with the 5 permanent members given the right of veto, because they had hope. There was a serious hope at that time and a sincere hope at that time that these 5 powers would work for the common good of the international community, putting their national interests, aligning them rather than aligning their national interests in fashioning a new world order under the UN collective security system. But that was not to be. And Winston Churchill, of all the people, reminded us at his Missouri in the 1946 conference, statement in Missouri, United States, that the new Cold War is already on. And with both systems of both competing East and West Europeans competing with each other in promoting the collective, their own systems of political systems and ideological orders. And that, of course, resulted in all kinds of problems, so many vetoes, and the right of veto was used and abused. And therefore, the United Nations Article 2.4 that was even considered almost non-functional. There was a debate in the American Journal, if I remember right, at one time, where some of the leading scholars at the time were arguing whether the Charter use of force, prohibition of use of force under Article 2.4 of the UN Charter was actually a dead letter. But that was only a kind of frustration, I suppose, of the repeated uses of force which were not controlled and which were defended as actually self-defense, wrongly or rightly, and then UN had no role to play. But then we have come to a current situation where we have one of the most important powers of the United Nations actually had to resort to military action for whatever reasons it keeps saying. But then this has created not only doubts about the very the very system of international law, which depends upon certain methodology by which disputes are settled, and these dispute settlement mechanisms have been completely bypassed and are not being used. And so therefore the urgency of restating the collective security system, the need for peaceful settlement of disputes, the need for honest brokers, mediation and other things that require securing the necessary peaceful settlement of dispute in a given case like this Ukraine is urgent. But more than anything else, Ukraine issue is only one issue that comes up and it has been among one of the latest one. But then the important thing for all of us is we have gone through this over and over again, whether it's Libya, whether it's Syria, whether it is other systems. Wars are going on for hundreds of 60, 70 years since the UN is there. What we need is a reform of the United Nations Security Council. And that is a major agenda item which has not been progressing as much as we thought it would. There again, common purpose is lacking, and then commitment to the goals of the United Nations World Order is missing. Therefore, we need to encourage that. Then, if in the absence of, even if the United Nations whatsoever, we have to also go beyond the simple political system. We must have a rule of law. Rule of law system demands that even the Security Council decisions must be reviewed and judicially reviewed, like any other system under any constitutional system. After all, Charter is a constitutional system. It's a system of the world, a veritable constitution for the United world. And therefore, as Brownlee has stated in his own head lectures, the role for the judicial review exists as an inherent power of the Charter system. And then he believes that, like any other decision, the Security Council is bound by the Charter principles. And Fujimori's long ago, even in the Southwest Africa cases, was trying to argue that certain decisions such as the Council are questionable if they are not in conformity with the purpose and principles of the UN itself. And then many other scholars have, over a period of time, like Eli Latterpack himself has done a great analysis of this matter. Derek Bowett has done it. And Brownlee came to the same conclusion after going through their work also, that judicial review is possible and decision taken with the purpose of maintaining international peace to be reviewed to promote collective interest or other special interest of the allied, the powers that are given the role to play on behalf of the United Nations, like the coalition is willing, that to change a regime, and that would become unconstitutional and questionable under the Charter system. So this is a question of judicial review. It is there, but it has never been undertaken. But it doesn't mean that in a suitable case, it could not be taken. It came very close recently, but it did not come through. So the judicial reform is important, and judicial review, the Security Council reform is important. Judicial review of the Security Council decision is more important and must be stressed again and again, and so that we can have a rule of law system once again reinstated and re-established and start functioning. Then we come to the more recent issues of climate change, and then the attendant crises that it has created already in terms of refugees, in terms of the bombing and otherwise, the kind of ill effects of this climate change. The Secretary General very recently, only 2 days ago, March 21st, when he was talking to the economist summit on sustainable development, has once again warned that the code red for humanity that was already indicated by the IPCC report and was reviewed at Glasgow is still upon us, and the commitments made by the states were falling far behind, and the $100 billion aid and assistance that was supposed to be rendered to the developing countries and developing and emerging economies and small island countries to survive against the odds of this climate change crisis is extraordinarily important and should be followed up. And so once this climate change on one hand and the wars that are continuing to beset the small disputes resolution, which could easily be done through settlement of disputes, because international has evolved so much and has covered so many areas, right from the acquisition of title to territory to islands which are isolated and otherwise abandoned in the oceans to border disputes. International works. So many disputes have come before the United Nations, ICJ and other Permanent Court of Arbitration and other arbitrations. They have shown time and again the value which the Institute of International long time ago argued that the settlement of dispute and arbitration is the way to go and not the wars. And particularly after war has been, use of force has been prohibited. So given this urgency to settle disputes peacefully, promote international law, and then settlement of disputes through arbitration and International Court of Justice should be the way to go. International, there is no need for me to say that international today, thanks to the Law Commission, a mention has already been made of the great contribution what Crawford and others have done during my time in the Commission to complete a 50-year-old exercise on state responsibility, a nearly 28-year-old exercise in my own case, with three rapporteurs coming before me on the prevention and liability principles, and then the later work that has also been done in many other areas like protection of atmosphere, but in the recent and others. All these things show law is evolving. Law is an important area where common consent can be put in for the common good, and it has been done, and principles exist, and they could be used, and they have been used, and we should encourage them to be used instead of resorting to these self-serving political acts and then unilateral acts and sanctions, which are totally undermining the world order. So my submission today to all of us is, please recommit ourselves to the United Nations system, demand settlement of disputes peacefully, and then always try to discourage these unilateral sanctions which are self-serving, not for the common good, and double standards, of course, exist in such matters, and I think we have to get away from that. If millions of people are undergoing great travesty of justice as well as living in extraordinarily poor conditions all around the world, 70 to 80% of the population, if we don't address their concerns, if we don't work for social justice, if we cannot bring in equity and equality of human beings without any race, color, and other things being distinguishing us, I think the world is still in a very, very endangered. And I think international law should work for it. International has the means to do it. It has the results. It has the number of times whenever it is used, it has shown its utility and potentiality to promote peace and justice. And that's what. Thank you very much.
Well, thank you very much indeed, Dr. Rao, for that very moving and forceful introduction. And I think all of us will agree with your strong statements about upholding the rule of law. I am just hoping, I would like the audience, we've got a significant audience here, and I hope the audience will participate by asking some questions. At the moment, they haven't come in. I realize in some parts of the world, it's very early. In other parts of the world, it's incredibly late, which may discourage people from intervening, but the floor is very much yours. First of all, a question has come in from CILJ. Thank you so much for such an intriguing discussion. My first question to you is, considering the economic and political issues, political realities of today, how optimistic should we be for the actual reconstruction of the UN Security Council mechanism, despite having scope to do so legally? And then the second question is, what are some key reasons for you to advocate for UN-authorized ADR mechanisms as an effective solution to the current global crisis, while such attempts have not been fruitful in the past? So I think if you go for the first question first. Dr. Rao, I think you're on mute. Dr. Rao, I'm afraid we can't hear you. You're on mute. Dr. Rao, we can't hear you. Oh, that's better. We can hear some background noise now.
Because of these things, I suppose.
I can hear you now. Thank you. I'm so sorry for that.
Yeah, I think I will do it with this. So you want me to wait for some more questions, or should we?
No, please go ahead with the question from CILJ and the first question that was raised.
Yeah, the first question is, how optimistic should we be about the reform of the Security Council? It's a question of we becoming optimistic. It's a question of effort that has to continue and persist, and it is being persisted. and there is no other way. If suppose, let us say the reform is not going as fast and as quickly and as otherwise smoothly as we wish to, the answer is to work on it rather than abandon it. So question is not optimism, question is persistence. So my feeling is there's no other hope. It will come through. Sooner or later, it will have to come through, given all the crises that is coming up and the climate change problems that are being coupled with this for the world order endangerment. I think it will come through.
Thank you very much. I'm glad for your optimism. And what about the second question that CILJ raises?
Repeat the second question.
And the second question is, what are some key reasons for you to advocate for UN authorized ADR mechanisms as an effective solution to current global crisis, while such attempts have not been fruitful in the past?
The ADR system means the alternative dispute resolution?
Yeah, that's right. Yeah.
Well, see, UN has had a string of successes in the first 60 years through mediation and conciliation and other mechanisms. And the UN has helped through the Law Commission enormous codification and progressive development of international law. For example, the entire law of the sea, which is as you know, 70% of the earth is covered by the oceans, and there is an enormous activity on the oceans, whether it is shipping, whether it is mining, now of course the exploration of oil, etc. Ocean has become much more integrated into our daily life. Environment is directly affected by the ocean and atmosphere. Under the circumstances, the law of the sea, which took nearly beginning with the Arvid Pardo's announcement, the statement in 1967. That was the year in which I started my work at Yale. I was there in September, and September 22nd, if I remember right, of 67, his statement came. So my Professor McDougall put me onto the law of the sea immediately. And that I took it for the next 25 years. And then we have 1982, the conference was concluded. And then we have now 1994, we have the further revision, additional act. So the point I'm trying to say is, with all the efforts that UN has been making, the systems of not only the ground level at the tapestry of international not only is growing and covering wide, vast areas, but it has been used to keep peace. We should remember that. If you have a problem only with the border areas and the ideological conflicts and some kind of spheres of influence, and then the geopolitical interests which have suddenly become too strong since last, let's say, I would not name names, but around 4 or 5 years from now on, I don't think we should be dispirited about the idea mechanisms and the opportunity. How many maritime boundary issues have been solved? Can you imagine that a maritime boundary issue between India and Bangladesh, which wasted 20 years for resolution politically, could be solved within a matter of 1 year through arbitration and 1.5 years by arbitration? And the entire Bay of Bengal is now peaceful area as far as maritime boundary is concerned between India, Bangladesh, Burma, Thailand, and Indonesia and Sri Lanka. And if you have these are all traditionally not very well focused on some of these ADR systems. So I think ADR system has proven its utility, and I think some exceptions are there, but the exceptions only prove the main point, and I believe it is a successful one.
Well, thank you for that very thorough answer. Questions are now coming in, which is terrific. And the next group of questions inevitably concern the situation in Ukraine. And they're reasonably lengthy, but the question from Dr. Omura says, following the footsteps of what we've already heard and global anxiety posed by Russia's special military operation in Ukraine, do you think international law under the UN system is problematic, lacking in its abilities to forestall against the use of force? Do you think that international law will continue to be polarized and defined by political ideologies of state subjects? I'll pause there to give you a chance to tackle that. And also, There will be another question on Ukraine in a moment. Do you want to just tackle that question about whether international law is problematic and really unable to deal with, for example, Russia's special military operation?
Well, if you say it is unable to stop it at the moment, yes, it is unable. It's quite clear, in spite of the universal appreciation of the applicable principles of international law have been reiterated right from the Institute of International Law to the international law to the many international law association and many other bodies of international law have already emphasized the importance of controlling border disputes and bilateral problems, whatever be their source, through international law. And as I mentioned already, international law has the necessary principles. And as the open aims of international law has long time ago recorded when edited by Jennings and Watts, international is a full-fledged system. It's no longer non-decay can be used as a methodology to decline a decision on the basis of international law. International is a full-fledged system. It's a full system. Therefore, it's a question. The order is there, the system is there, and then if individual parties, for whatever reasons of their own limitations and inability to reconcile to their private problems, I think the only ultimate result is coming to United Nations and then coming to the settlement of disputes on the basis of international law. For example, all the Second World War issues, First World War, Treaty of Versailles, then this San Francisco Conference, are the result of conflicts. And Ukraine is it's true, it's bothering us like a needle in our thigh, but then it will go, it cannot sustain. This kind of conflict cannot be sustained for too long by the parties themselves. And I think mediation will come in, and I think necessary elements have already been identified by various very perceptive diplomats and negotiators who are well versed with the area and the conference. And I think I don't want to go into the elements of a possible compromise, viable compromise between the two parties. Parties themselves are talking, and I think the only thing I don't like at the moment is the high level of rhetoric by the presidents and prime ministers who matter in the matter, to constantly trying to show aggressive intent to continue this conflict. I think there must be more. The tones must be lowered, and I think they should meet each other as often as possible, and they should not be talking about how they can hurt the other person, rather than how to yield to each other's immediate interests, and sometimes some of them are reasonable interests, and then try to assure them that they are not bent upon extinguishing each other in this ideological battle. I think there must be room for compromise. The rhetoric is causing all the problem, and if the rhetoric is lowered, we can get solution.
Thank you. That's a very helpful and full answer. There's a question here from, I'm afraid I don't know the person's name. They go by Upperstum, but that presumably is a mixture of surname and first names. But the question is, reforming the Security Council and stronger rule of law in the UN system would require changes of the UN Charter, which will be blocked by the veto powers of China and Russia. So you have to propose more realistic alternatives. Can an alliance of democracies push for your proposed reforms if so many UN member states do not support sanctions against Russia's war of aggression and war crimes? How? And sorry, I apologize. I've just been told that's Ulrich Petersman, so I apologize, Professor Petersman, for vulgarizing your name.
No, but tell me, Professor, what is this question? Is some of the question is because it looked like a statement to me.
Yeah, I think the question is, how do you make the rule of law changes that are needed given the veto powers of China and Russia?
Oh, I see. Well, look, Law Commission is a body of the UN. It's a continuously working, and it has agenda items. Even when it is unable to of late, since let's say after 60 years of its existence, and particularly when during its 70th year, it has been identified as some of these unilateral actions and by the political rivalry between ideological political rivalries between the great powers, causing a great concern for enacting new convention. There is a fatigue, treaty fatigue is there, according to the observers of the UN work and the Law Commission work. But nevertheless, in spite of that, a number of, for example, take my own subject, prevention of transboundary harm and as well as allocation of loss. We have identified due diligence principles, and as part of that, we have identified several principles of environmental impact assessment and the consultations together, and then reasonable and equitable use of resources in allocation manner, and then many other principles that have evolved. I don't have time to recall all the nitty-gritty of, but all those principles today, for example, are great value in dealing with cybersecurity issues, in dealing with climate change directly, and then global commons, protection of global commons, even though they were predicated originally upon what you call the bilateral and physical harm only. The prevention and liability articles were predicated upon physical harm, transboundary physical harm, the identifiable harm, whereas global and single source identified, and then you try to prevent it. But then in the global commons, we know it is multiple sources are there, multiple countries are involved, and then the levels in which they interact and are not clearly identifiable. The like in the tort law business, you know, the cause and action cannot be, the causal connection cannot be easily established, etc., etc. But nevertheless, these principles of due diligence, the newer systems of evidence, the building up evidence as to what are the sources of causing the problem in science and technology, are helping us to come closer to applying due diligence obligation in a broader fashion. In other words, what does due diligence obligation require? Due diligence obligation require only do the best you can under the circumstances, given the knowledge you have, and then try to provide for necessary measures to prevent the harm as far as possible, and where it occurs, try to alleviate it. So due diligence does not prescribe a set standard. It's not set in stone. They're similar. In what I'm saying is, principles like that have been developed in different areas, state responsibility also, for example. And incidentally, in state responsibility and sanctions, I must tell you, the fundamental principle under which countermeasures, when Crawford was trying to promote the subject in the Law Commission, the countermeasures when they were signed, in fact, I was one of them, was arguing, are we not going back to the undermining the UN system itself by allowing this making countermeasures lawful, without offering, like Aranjori was argued, for a settlement of disputes as a primary condition. Only if it fails, then countermeasures. So you must offer first a settlement of disputes, and that became a big controversy. But then Crawford and others have argued that the countermeasures cannot be done without regard to human rights, without regard to such jus cogens, without regard to many fundamental principles of the UN. And if these things are not taken care of in the process of promoting these sanctions, which are otherwise necessary according to these people, being the absence of any collective security system, they are not such, once they initiate it, they don't have their own life of their own, and they can run on their own speed and on their own direction. They are also controlled. There are limitations on them. Therefore, some of these concepts exist, and therefore it's not the Security Council and the collective security system itself that should be our focus, because that is the source of the problems. But it should not discourage us from thinking there are other ways of controlling and judging. For example, murder can take place, but then when the murderer is eventually caught, he is booked under the principles of law which are already established. So if while the process is going on in locating the murder, it doesn't mean the law has lost its value. Law is waiting.
Thank you for that. There are a number of questions coming in, which I think basically can be summed up as frustration at the potential impotence of international law and international fora in the face of activities by certain states. For example, one anonymous attendee says, my question would be with regard to the workings of the ICJ. There are no ways to enforce the ICJ rulings, which is one of the reasons why states get away with their wrongful actions, especially the powerful ones. Are there any practical solutions to this issue?
Yes, I think the practical solution is, see, public opinion, culture of compliance are the two major sources of enforcement of international law. This is, all of us who are practicing in international know this. We have, in fact, the argument was when we were students and even as we grew up in all these years, the reality is law, we create the law, not because somebody gave it to us. We created the law because we needed it, and that's the only way we can accommodate each other. And once we did that, because we wanted it, we follow it. Go on the right side of the road, drive on the right side of the road. It's a culture of compliance. The people do that simply because everybody is doing it and it has been found good. Customary law is like that. And therefore, the important point here is, in spite of the transgressions, in spite of the exceptions that keep coming up, unfortunately, rather strongly in a very particularly forceful way, we still have to show, rest of the world has to show, the public has to show, you and me, and the students, the teachers, the public opinion, the politicians, the normal man has to keep on putting trust in that. And that's the only way you can isolate those who are transgressing and those who are not falling in line. And then they will, once they know they're in a minority and they're not being liked, they will certainly conform. Therefore, the rule is, the question is not because somebody is become wayward, we should not be confused. We should, that, as you rightly said in your opening statement, Professor, this is the time when international should be accepted. The value should be constantly talked about, and its achievements have to be constantly advertised, and then the people must, their faith must be restored. And I think that's the answer to that.
I really appreciate your enthusiasm and your strong reassertion of the values of public international law. But we've had two more questions that have come in, one from Uganda and one from Sierra Leone, which essentially are asking similar facets of the different facets of the same question. One is from George Darlington Hashaka. Would it be prudent for a permanent member of the UN Security Council to be relieved of its membership once it's abused international law like Russia has done? And then I'll pose to you the question from Sierra Leone in a moment. Do you want to answer that one? Can you remove
Yes.
a permanent member of the UN?
Yes.
And would it be a good thing to do?
No, I tell you, I will not be interested in outcasting anybody. Because you remember, again, I was speaking of Sir Winston Churchill earlier, of his Missouri lecture. In that lecture, even as he was complaining about the onset of Cold War, hardly even before the United Nations commenced its journey, he said another sentence in that lecture. I think people should read that for what it is worth. I'm not recommending that it has an all-pervading logic to it, but from the point of view of the Eastern Europe and others, why they were doing what they're doing, of course, has to be explained in their own words, I suppose. But he was reacting to a situation, and one sentence he said was, peace of the world. Of course, Europe was the central focus in those days. And after all, we know since 1648, one of the problems we have with international law is it is worked for Europeans and the rest of us only going with it. And so that's why the critical third world and all that, So I don't want to go into that for lack of time. But the important point to know is today also, at that time, Churchill said, even when the Cold War affecting already the UN, even its inception, he said, we should not make any one country in Europe outcast, because even if one country is outcast in Europe itself, the peace will not be restored. In other words, unity is necessary, and bringing to the hearts of the people should be necessary. Addressing some legitimate concerns is absolutely important. Sometimes I would say even not so legitimate and unfounded concerns also should be heard
and listen to, like we do in the family, you know. When a child comes and shouts at you, what do? You just laugh and then listen to him as much as you can, so that he can unburden himself, you see. But on the other hand, you will start slapping him and you don't allow him to speak, he will become that much more violent, you see. Therefore, the same thing should be applied here also. We all know what's wrong, but handling it with certain patience, with certain courtesy, with certain affection, but giving the feeling we are together to one way or the other will bring us together, not throwing away people.
You're clearly a much better parent than I am. I would say that, but more seriously, so in which case would you believe that any action should be taken against Russia, given, as you said, that this war will eventually end?
Yes, well, no. I think the Russia should be asked to account for its actions. Russia should be asked to pay all compensations if the actions found to be genuinely, as we believe today, and genuinely so, contrary to international law. By all indications, they seem to be so, and they could have easily pursued their objectives in a peaceful and even if it's slightly confrontational, not using force at the level and at which at the scale at which it has been utilized. After all, border clashes are taking place all around the world. After all, wars are taking place, and non-state actors are participating all around the world, and particularly in the Middle East and other places. There's a constant problem there, whether it is Yemen, whether it is Syria, whether it is Libya, whether it is Iraq, and we have seen that. And in Latin America, we have seen mafias running around and taking law and creating such chaos when the refugees are constantly flowing out of it like through caravans. And all these things are going around. And all this problem, and Ukraine is only a matter of gravity because of the nuclear weapon threat is involved, and because of the great power which is supposed to be defending us became one side of the party to the whole matter, and they are not getting, according to them, the kind of hearing that they wanted to from the other side, and the other side was constantly encircling them, according to them, and there is a fear complex that is somehow generated. As a joke, I'll tell you, I think this COVID has really thrown us off our balance, the mental balance. Sitting at home and not doing anything else, and then all the time worrying about the nearest person coughing. I think we have lost our balance. I think great powers, great leaders also could lose their balance in situations like that. This to COVID, I have a feeling the COVID and the restrictions and the isolation that has pervaded the world order for 2.5 years, has something to do with this.
Thank you. I'm conscious that we're running out of time, but I said I would return to the question from David Joseph Aliou, and forgive me, David, if I've mispronounced your surname. He says, again, it's this frustration, this theme of frustration with the international law structures. He says, the action of Russia has made the UN Security Council, I guess, an irrelevance. It seems as if they are a toothless bulldog. How can the UN sit and watch a member state be invaded and all its infrastructure destroyed with impunity? What is the essence of UN? And he adds NATO. If you focus, I think, primarily on the UN.
Well, I tell you, there's only one single sentence answer to this. Do we want a third world war? I think the consensus exists. No matter what's happening, third world war should be avoided, and third world war without nuclear weapons is not possible. And I think that's even a greater danger. I think we have to live with a lesser evil in trying to attack it. We should not invite a greater evil.
Well, I think on that note, I think there's something we can all absolutely agree on. I think the prospect of a third world war is so horrific that I don't even think we should be, that's a subject of discussion. I want to start by saying thank you enormously, Dr. Rao, for your time, your attention, your thoughtfulness, and your positivity in the face of really quite difficult circumstances. And I think it's to be admired that you are determined to uphold the values of the rule of law and the values of the international legal order. I'm hugely grateful to you for your time, as I'm sure are all of the organisers. I won't give the floor back to all of them, but I think I can speak on behalf of all of them to say thank you very much indeed for your intervention this morning. And thank you too to the audience for the excellent questions that have come in. I think I bring this session to a close. I think the next session starts at 9 o'clock. I don't know if Ollie Hales or Darren want to say anything at this point, but if not, they're not indicating they want to speak, in which case, can I thank you very much indeed, Dr. Rao, and please do stay with us for the rest of today. There's a fantastic program ahead.
I'll be keeping in and out, but then I'll certainly be happy to join you, and because I love to be with you people. And I think when I see the young people on the screen and yourself and others who are listening, I think we have a common cause together to keep pronouncing the value and the importance of international law and building up a rule of law, which is, you know, there is a big difference between rule of law in the international system and the national system. I used to say in one sentence, if national systems are also now under great trouble, it is like, it's a different from the trouble we get at the international level. In the international level, the rule of law is like building castles by the side of this ocean in the sand castles, and the waves keep coming and then disturbing them and then removing them, and again we build up the new castles, you see. Whereas in the national system, the rock solid the forts are being decimated, and now they are becoming relics of the past, like Roman, the relics in Rome and etc. So the national system of rule of law is a relic of the past, whereas the international rule of law is something that is work in progress, but somehow never getting there. but we have to work it. We have to work it.
Thank you so much, Dr. Rao. Very nice to have met you. And thank you to you all.
Thank you very much. All the best. Welcome.